So, hi, everybody. My name is Deanna Clark. I'd like to welcome everybody to our first town hall. This town hall is on how to stop FDA's proposed vape import ban. And I'm thrilled to be here with Mark Anton, who has been a friend of mine now for several years. And I'm going to introduce him in just a moment. What I'd like to do is to first go over what the agenda will be for our town hall. And I'd also like to give a big shout out to our sponsor, B2B Wholesaler Magazine. So here on the screen, you can see our agenda. We're going to start with some introductions. We'll then talk about what exactly is a proposed rule, along with what is this particular proposed rule. What's at stake here for vape importers? How can vape businesses push back against this? What happens once a comment is submitted? And then we'll turn to a bonus that we're offering all of you for attending today. And we'll open it up for Q&A at the end. So with that, I'd like to start with an introduction. Mark, may I introduce you first?
Sure.
Okay, thank you. So Mark Anton has been involved with the vape industry since 2008, and he is the CEO and founder of What a Smoke LLC, which is an e-cig liquid and vapor device manufacturer and distributor. He is the holder of 2 vapor patents and is a passionate entrepreneur. He has served as both the executive director of Smoke-Free Alternatives Trade Association, which is otherwise known as SFATA. He and I are here with April in the middle here when we were at an event in Connecticut promoting SFATA and all the good work that is done there. He has served as a legislative director for federal matters with the New Jersey Vapor Rights Association, Vapor Rights Coalition, rather. And they represent retailers in the state of New Jersey. And he's also on the board of advisors of a hemp manufacturing company. Mark is passionate about the industry and has testified before the FDA. We have gone together to Washington and lobbied together for the industry. And he works with multiple associations to promote the vapor space before legislative bodies. He's worked with the National Institutes of Health to develop both an ENDS product for research and testing, as well as a hemp pulmonary delivery device. He holds a Bachelor's of Science in Business Administration from Montclair State University, with a major emphasis on finance and a minor emphasis on industrial studies. After initially focusing his efforts as vice president of operations and plant manager in the manufacturing sector, as well as the defense sector, Mark has founded Lynx Marketing LLC in 2001, which provided a variety of branding and support for clients, including Armor Electronics, Real Vegas Slots Inc., Enjoy Electronic Cigarettes, Raytheon Lockheed Martin, and Resorts Atlantic City Casino. Welcome, Mark.
Well, thank you, Deanna. That was very kind of you to say. And I'm really, it's a pleasure to be here. And it's an honor to be able to go over this with you. Because as you know, I am very passionate about this industry. And it's unfortunate that we're always having to fight. But we've got a lot of experience at doing this, so hopefully our experience will be able to be transmitted over to the people who are attending here today, and they can take advantage of the opportunities that we're presenting here today and how they can deal with this. But I would like to take this moment to introduce Deanna Clark at this time, so you all can get to know her a little bit, because as she said, we've known each other quite some time. We met back at NYU over 7 years ago. That was our first time, and we worked at SFATA together, as you saw. So Deanna is the managing attorney for Clark-Esposito law firm with over 20 years of legal experience in U.S. customs law and import compliance, as well as regulations from U.S. Food and Drug Administration, the Alcohol and Tobacco Tax and Trade Bureau, and the Drug Enforcement Administration. She specializes in the regulatory frameworks for vape and tobacco products, food, dietary supplements, and hemp products, offering comprehensive support to businesses navigating these complex areas. Deanna and her team are adept at handling a wide range of issues, from responding to FDA warning letters and applying for licenses and approvals to managing pre-market tobacco applications, otherwise known as a PMTA, obtaining the release of seized merchandise like e-cigarettes from U.S. Customs, and addressing enforcement actions. They focus on delivering practical client-centered solutions that streamline regulatory compliance and resolve problems efficiently. Well, welcome, Deanna. It's a pleasure to be here again, working with you in another vape subject.
Indeed. Thank you. All right. So now I want to go ahead and turn into the meat of the subject. And I want to get into what is a proposed rule. I first want to mention, though, that this topic, import law, FDA law in general, there can be a lot of confusion around what it is. And so I just wanted to share that we do have a law firm YouTube channel, which we invite you to check out after this program. We will also be sharing this video on our YouTube page, and you can come over and subscribe. So talking about what exactly is a proposed rule, I just want to give a quick background on this and really combine it with the next one. But, in its simplest form, a proposed rule is a way that the government announces that they want to put a new regulation into effect. And so under our Constitution, we have something called due process, and there's a notice and comment period. So the government has a way to say, hey, we want to do this, what we have right now, this proposed rule is their way of saying, here's what we want to do. And in terms of what this proposed rule is, I want to take a step back from FDA and talk about the U.S. Customs side of things, because, the intent of this is to make FDA's life easier. U.S. Customs views importing as a privilege and not a right, and all goods must comply with U.S. law at the time of importation. What does that mean? It means anything that FDA says, hey, this must be this way, Customs, as the policeman of the border, is then there to say, hang on, shipment, do you comply with the laws of FDA and any other government body for that matter? So with that, they're looking to make it easy for them to enforce that. Is this a lawful product or is this not a lawful product? And the standard by which FDA is saying this is a lawful product is, has there been a PMTA in progress at the very least, so that there is this STN, this tobacco number issue. Okay. So this is the overview of what this is. And the rule itself is saying that this data point needs to be added at the time of entry. So customs entry is the process of getting things into the United States, and it's paperwork. The paperwork is now electronic, and the electronic paperwork is run through something called the Automated Commercial Environment, or ACE. ACE came out over a decade ago because it was the government's attempt to make it so that the agencies could communicate with one another directly, that they had one single database to obtain information about other agencies from. And so FDA is able to use ACE and communicate with customs. The customs entry form, which has several data points, including the manufacturer's ID, so just thinking about what's being declared, who you've bought it from, who is it going to, whether that's a third party or the ultimate consignee, which is the receiving party, the ultimate receiving party, and a bunch of other data. So they want to add another data point for this STN number. And by having it, supposedly anyway, it will streamline FDA's ability to say, hey, yes, this complies with our laws and therefore it's admissible. Because items like bongs, for example, they may come in, but because they're considered drug paraphernalia, they're considered inadmissible. And the way the FDA has it set up, it's without having this marketing granted order saying, hey, we give you permission to sell this in the United States. They consider it what's known as misbranded or adulterated, and therefore it cannot come into the United States. So this proposed rule is just to make this one change in the way that the customs entry collects information, so that through ACE, this shared digital system, they're able to see, yes, this is admissible, or no, this is not admissible. So with that, I want to move into what is at stake here for vape importers. And I'd like to turn it over to Mark to hear your initial comment.
Well, thank you very much. And I'd like to go back a little bit because the title of this whole submission really tells us a lot of what the FDA is doing here. And it's a docket number FDA 2024-N-111. It's a submission of the Food and Drug Administration import data into the automated commercial environment. And this is the key for certain tobacco products. Even though the FDA has regulatory authority over all tobacco products, from deeming from the Tobacco Control Act, as it's aptly known, TCA, or from deeming products that weren't currently listed in the TCA back in 2016. But what's very interesting about this is you read through this submission, they're requiring STNs, which Deanna had mentioned before, which are submission tracking numbers. So for anyone who's filed a PMTA, you know what these are. You've got them, you've seen them, right? It means that the FDA has acknowledged your filing of your pre-market tobacco application. However, this only applies to ENDS products. It doesn't apply to pouches. It doesn't apply to anything else other than ENDS products and their components and parts. So because of that, it's really a very specific way for the FDA to restrict importation because they're having a hard time controlling this market as it currently stands. And as all of you know, the FDA has only approved tobacco flavored, and currently they just approved a menthol electronic cigarette that with a marketing granting order. So with this STN number, the FDA has made a number of specific claims that, one, it would save money, specifically to the FDA, right? Because they wouldn't have to then go and review all of the products that come in through customs through a manual process. This process would give the importer the ability to get an automated granting or not granting. As they mentioned, that just because they might let the product in does not determine any other future events, such as giving a marketing granted order. But what it's actually doing is putting the onus on every vapor manufacturer to file a PMTA, which of course we know that to stay in this market, you would have to get a granted order from them. And as all of you know, this has been a long process and it's gone through many regulatory and legal challenges along the way. And we're still waiting for the Supreme Court to actually address this. So this is really a big issue because, as we just saw in committee hearings, that 90% of the current market share, as the FDA and Congress see it, is in the hands of flavored disposable vapes. And I am not currently privileged to know how many of them have filed their PMTA. We do know that a number of them have been receivers of actions from Customs, Border Protection. And so this would, if this goes into effect, and if this is given to them and it goes through the whole process and it becomes federal law, which that's what it is. A rulemaking is given a full weight of law, just as if Congress passed it. So we would all be beholden to follow this process to import our products. So this has the potential to restrict a very large segment of products that are currently being sold in multiple distribution venues, such as convenience stores, vape shops, vape and tobacco stores, wherever it's being sold, really, because importation would be very much restricted using this procedure. So it's important for everyone in this industry who's concerned about having these products available for their clients, for their customers, for themselves, to actually go and make public comments. And we'll talk about that a little bit further. But this automated process is really a way where if you don't have a granted order, we could see just literally tobacco and menthol flavors as the only products that are available to come here. And due to the fact that if you are adulterated or misbranded, your product would not be allowed to be imported into this country. And they can also do other actions regarding that, such as fines, trying to import illegal, well, adulterated or misbranded. I love that term. Because basically that means you haven't gotten approval, so it doesn't conform with our instructions, so it's adulterated or misbranded. So, and what's at stake really is one, confiscation of your product, so you can lose your investment. Two, that your products would not be able to be sold in the United States. And three, it's not a guarantee that they'll give you the ability, if you do have an STN, to import it. Because remember, everything the FDA is doing right now is at their discretion. So as a business, it's a very hard thing to actually ascertain and do proper decision making, because it's all at a whim. It's an automated process. So what that really means, if you read the rules, it's more of a, instead of the FDA going and doing a physical inspection and then looking at the product, they can just look at the STN number and then basically press a button and say yes or no. And so your decision making is really up in the air in how you're going to run your business moving forward, if this rule goes through. Because currently right now, and I don't think Deanna mentioned this, that the current structure is that this is an optional function. So if you've been given a marketing granted order, you have the ability currently to put the STN numbers into ACE and have this process facilitate or expedite your importation process. So being an optional one, I suspect that the companies that have been given a granting order are currently using this process to facilitate quicker customs and border protection, release of that product. So an option doesn't hurt anybody. However, requiring an STN can hurt many companies that are looking to import their products that they've probably been importing for years. And that's the thing, because it is anything that is not just a finished good, but a component or a part. So
Absolutely.
yeah, and we can't forget that, because that's devices which are not even made of a tobacco product. It's and it has multiple functions that you can certainly see or apply it to other things. But it's going to be incumbent upon your importer, your customs broker, to actually know how to navigate this.
Yeah,
So,
and what's frightening too is, it's even let's sweep in batteries, let's sweep in essentially everything. Oh, well, my
mhm.
empty vape pens are not even intended for nicotine. Well, we're going to take it and you come back and prove it, right? I mean,
Right.
it's really just sweeping, what is it, the baby with the bathwater or something? Um,
Yeah, that's throwing it out with the baby
yeah.
with the bathwater. But yeah.
And critically, the process of what they want to implement is that at the time of entry, there's actually an affirmation of compliance. They're calling it an
Hmm.
affirmation of compliance for tobacco submission tracking code TST.
Yep.
And this TST code is requiring the STN to be submitted in ACE. So,
Correct.
your customs broker had you sign a power of attorney, and that power of attorney says, I'm just your agent to conduct customs business for you. So anything that they're doing is simply being done on your behalf. And by having this requirement to certify, now it's putting any importer who, is importing but doesn't have the number, uh, that they're certifying, hey, we do have it. And one of the difficulties there is your intent. So, oh, okay, well, you said this, but you meant something else. And what customs does is they have their own office. It's known as the Fines, Penalties, and Forfeitures Office, FPNF. And so, where there are imports that are now considered violative, they get seized.
Hmm.
Even though you never get those goods, FPNF can still issue a seizure notice.
Hmm.
And then it's, oh, okay, not only did we lose the money on the merchandise, lose the money on the freight, lose the money on the insurance, because insurance won't cover a government seizure of the goods. Now it's, oh, and on top of that, I've received this. Another problem that can come up is this idea of it's a privilege and not a right, is they can actually revoke your ability to import. Then right now, most commonly your importer ID number is pegged to your tax ID number. So, there's no getting around anything. It really is, here's what we're doing, here's what's happening. And I can tell you, under constitutional law, we actually look at something known as intent versus impact. And supposedly, the purported goal is to help FDA in making admissibility decisions and automating that process. So just, yep, okay, this can come in. But of course, we recognize that the impact will be huge. And to piggyback on some of the things Mark had said in terms of what other impacts there could be, we will see the states, I don't know to what extent or how they may go to push back, but right now, we know that states are heavily relying on all of this new income that they've been enjoying from the
Hmm.
taxation of vapes and, of course, disposables, because that's the majority of what we're finding in stores. So, there's a ripple effect. Never mind the whole black market piece, that we could foresee. But there's a real ripple effect. And Mark had talked about how they're pinpointing and specifically targeting vape products, these ends products.
Yeah.
Um, and, Mark, what do you think is behind this? You know,
Well, I think there's two things, as I mentioned uh, earlier about the committee hearing. The committee hearing was certainly one that had a lot of concerns about Chinese products or Chinese disposable vapes, right? The theme the theme was very focused around that aspect, and what is the FDA going to do about it? So, and the other aspect in his Brian King's testimony was very specifically that they were looking to get another $100 million in user fees. And they were currently discussing, that the vape industry is not under the user fee structure, and they're trying to get us under the user fee structure. But how they do that is they have to have reliable data on that. And if they have an automated system where the companies who have an STN, who have been given a marketing granted order, by requiring this, every single importer of approved products would then be accounted for. And so the FDA could certainly be able to collect the data that they need to make their case for including the vapor space in user fees, and number one. And number two, making the case for they were looking for $100 million to expand their abilities at CTP. For what, I'm not really going, all I can do is go by what he says, and it's to expand their enforcement side of things. So this would certainly go into that. And when you read this, it says that the FDA did this with the Department of Treasury's concurrence. So they had actually sought the Department of Treasury's input on this, just to make sure that they could collect this data. And I think that's a very important thing. But, I do want to step back a little bit here, because the FDA makes the statement, that small businesses would bear the costs of the rule like everybody else, because you got to read it, you got to apply it, you got to put it into practice. But then they say that if finalized, we would also enjoy most of the benefits, because we would just face some minor one-time costs. Now, this all goes through an economic analysis, and if they don't see that there is more than, I believe, $200 million of economic, I forget the term, but economic impact, that's it, that they don't need to do a administrative, they call it very specifically a regulatory impact analysis, right? So that means they would have to go through and look at all of the costs associated with it. But what's interesting about this is, to get an STN number, you have to do a PMTA, and they haven't put those numbers into this particular proposed rule, right? Because it's applied to a whole nother proposed rule. So they can, in their mind, ignore that. However, when you're talking about a $7 billion industry and the approved products are only 11%, you can do the math yourself. You're still talking over a $6 billion economic impact to the industry. That's a lot of money, and they did not do a regulatory impact analysis. And there are a number of factors, executive orders by both President Clinton and President Obama, and they require certain aspects to be considered when you're doing a proposed rule. And I'm just going to read the first paragraph from the Health and Human Services website, so you can understand this a little bit more. So the executive orders call for a regulatory system that protects public health, welfare, safety, and our environment. Those seem all very reasonable things, while promoting economic growth, innovation, competitiveness, and job creation. Just that first sentence alone, you would have to look at the essence of this rule to determine if they are encouraging or promoting economic growth, innovation, We know that the industry's already innovated because the consumers have said these products are the products that we really like to use. But now, without an STN, those products will be removed from the market. Competitiveness. Well, you have what, 3 companies that have gotten marketing granted orders, and they're all very large companies. So the small companies will not benefit from this rule, as they say. It's the 3 larger ones, and they can already use it. So it doesn't really make much sense. And to achieve these goals, the Department of Health and Human Services analyzes the benefits, costs, and other impacts of significant proposed and final rulemaking consistent with the requirements of the executive orders. So that being stated, we can see where they're not really considering those factors when they're doing this proposed rule. This proposed rule is really for more of an enforcement arm for the FDA. And at the surface, it's not a terrible thing if they had a proper regulatory environment. But since they've not given a proper regulatory environment, this has the potential to constrict the marketplace and actually have an adverse economic reaction.
Oh, indeed. And we had talked a little bit earlier about the tax, impact across the country.
Mm-hmm.
Which, as an aside, I recall talking with the tobacco, regulatory arm in one of the southern states, who unequivocally said, e-liquids, that's not tobacco, before they got on the let's tax e-liquid bandwagon. But, go ahead, Mark, you wanted to say something?
No, it's amazing how that transition happens very quickly when they realize they can put a tax on something that people won't push back.
For sure. There is a lot at stake here. Just Mark, in the interest of time, I'm going to go on to
Sure.
How can vape businesses push back against this? And so at the beginning, I had shared how there's this notice and comment period, right? Capability. And in relation to this proposed rule, what pushing back means in one sense, and then Mark, I'll let you share,
Sure.
reaching out to local folks, congressional and city, state, et cetera. But the first line of attack is to submit something called a comment. And what a comment is that it's something that industry, so both pro and con, you can expect comments made on both sides. All are considered before the final rule, so the final regulation is issued. For each type of comment written, they will respond, and they'll respond in writing, okay? Now, importantly, anytime you're providing a comment, it needs to be kept specifically to the scope of information provided in this rule, and not to digress or talk about other things, because they will come back and simply say, hey, outside of the scope, sorry, I can't respond to that. So as you're thinking about what you want to say, you want to keep in mind, let's just hone in on what they're describing in this rule and not delve into things that are unrelated. These public comments help the agency because, in some, it's like, oh, well, what are we going to do? They're going to pass this law. But I want you to understand your comments can help shape the thinking, that the agency has behind this. Could be for clarification purposes, terms, finding them. It could be explaining, for example, how there will not be a reduction in the financial burden. We know, as Mark talked about, the PMTAs, they're really expensive to do. Now, there may be a little more wiggle room on that, following a court case that the Supreme Court will be hearing. We just refer to it as the Triton case within this current Supreme Court term. But until such time, right now, FDA's treatment of applications for tobacco products in particular ends, is just basically a sorry, not going to give you a granted order, right? Um, Comments can also be used to enlarge the time frame for its implementation. But I think the goal with this one is beyond an alternative, we want to see this not become a law, right? And so any comment we may make, it needs to be constructive. It needs to be an information-rich comment. So your claim is really supported in a way that the government can say, oh, okay, yeah, that relates to what National Institutes of Health said, NIH, or, oh, okay, you're directly involved in the industry. Here's how it's going to impact you. That's something we didn't consider. Mark, do you want to elaborate on that as you were talking about the regulatory impact analysis?
Yeah, I think that, the FDA gives us 4 particular areas of interest that they're inviting comments on. They certainly didn't make the RIA one of those particular areas, and just because they invite comments on very specific areas does not mean you are unable to point out discrepancies in their rulemaking, right? And when doing that, it then makes them have to look at, okay, did we actually miss something? Did we not look at this properly? Or are they just considering it as part of the PMTA and therefore it won't have an effect? But we do have to look at the millions of people who are currently using this product, and they're supposed to protect and promote health, right? That's the first part of that sentence that we read. And if they remove these products, what are the alternatives? What are the options that those people have? I've seen, since I've been doing this, I've seen them shift on certain things. Granted, we have to remind ourselves this is their current thought process, right? And they've already gone through OIRA's review after they've drafted this, and now it's into public comment period. And the public comment period is a very important period because it gives stakeholders the ability to voice concerns over this proposed rule. And so you have to look at this proposed rule and what it actually potentially has the ability to do, whether it's intentional, unforeseen, or it's just meant to maybe streamline things, right? But we know everything government does has multiple reactions. It's never just as streamlined as a proposed rule. Never. They don't consider the consequences. Look at what they did when they when they banned flavors and pods. You got disposables. Right? So
Yeah.
not everything is as straightforward as they like to think. And you folks all have that ability to really see how something like this might affect the industry, how it might affect how consumers are now put in a different position. Does it have the potential to eliminate a large portion of the market? Then does it then switch over to pouches, right? So there's a lot of things that we see have cause and effect. And so in this particular instance, writing your public comments in regards to this rule, you want to make sure that you clearly state what point you're focusing on, right? Not all of us have large abilities or monies to hire lawyers and scientists to write all these things. So you have to look at this from a perspective of how is this potentially going to affect my business and my customers? And that's a very straightforward way for a smaller company to do it. And larger companies can look at the potential as to, if they don't have an MGO, but they're still going through the process. I mean, let's just take White Lions, for instance. They have an STN. They
Yeah.
got an MDO that was overturned. It's SCOTUS. So how would they be able to know whether or not their products, if they did in fact import products, wouldn't be held up and seized at the border?
And that can actually happen at any time,
Mm-hmm.
you know. And again, I mentioned the data points, and I think I mentioned this manufacturer's identification number. So US Customs already knows and has historical data on who is manufacturing what. And the what,
Mm-hmm.
you have to appreciate anything that enters the country has a 10-digit classification number. And that 10-digit classification number specifies if it's an end, if it's a part or component of an end, down to that level of detail. The other thing that I want to mention, and actually Mark mentioned this to me yesterday when we were talking about this program, is you want to also send your concerns and comments to your congressional members,
Mm-hmm.
Senate, House, along with your local representatives, because at the end of the day, talking about the tax revenues, for example, talking about the impact on, hey, our business supports this many families, and where else is your business supporting other businesses, other families? The impact is bigger than just your company. And so you want to reach out not only by submitting your comment, but you want to reach out locally and ask them to get involved, ask them to share their voice, ask them to submit a comment as well.
Right.
Right.
And part of that too is educating your congressional members, because one thing we don't really talk about, because we're talking about submitting our comments, but we have to remember these regulatory agencies are actually part of the executive branch. And Congress, not that they have in the past, but they can void or write a law to invalidate a rule, which we haven't really explored very much in this industry, or made a concerted effort to, like the deeming rule, right? That was something that if we went to Congress, we could say this was not the intent of the TCA. It's obviously here, it's in the congressional records. But now that this is here, it's putting these burdens on us. And, instead of the news and the all of the, I don't want to call it misinformation, but all the hysteria over the youth issue, we could certainly have done a campaign to really educate Congress in a very significant way, but it's too strong of, it's too expensive. It takes a lot of effort. So the best way to deal with this is really with your public comments.
Absolutely. So let's talk a little bit about what happens once a comment is submitted. Generally speaking, everything goes quiet for a while. They will wait for the window to close. So we're 20 days out at this point to the deadline,
which is October 15th.
October 15th. And
at midnight.
And fortunately, it can be submitted electronically.
Yep.
However, if you want to provide what you consider to be confidential information, then that does need to go by mail. So you'll want to keep that in mind. You'll also have an ability, once submitted, you can comment on other comments that have already been submitted. So once your comment is submitted, and even before, if you want to piggyback on somebody else's comment, you have an ability to do so through the portal. And Mark, do you have any comments in relation to this?
The only thing I'll say is they do read them. There are times where I remember they tried to say that a lot of these were robots and bots or something like that. But for the most part, they do read them, and they do comment when they make their final rule, especially if something is very pertinent and or can have a position for litigation at a future point.
Mm-hmm. And thank you, Mark, because I wanted to say something about this. submitting a comment, this whole process, it is not actually a one and done, if you will. What ends up happening over time is because the agency has responded to the comment, that is now, believe it or not, it's substantive support with making legal arguments in the future. So a question could be raised in the comment, and where the government provides an answer, let's say 3 years later, Congress has made some changes, you're now being hit with a penalty, a violation of something. And it's, well, hold on. I know from this response to this comment back in 20, well, probably comment next year, but 2024, 25, FDA's thinking was such and such. And based on their thinking, we acted in this way. And therefore, you have a viable basis for why you took the action you did. In the event, for example, you find yourself defending against some sort of alleged violation. So
Right.
submitting a comment, getting their feedback, which gets written up and then published in the final rule, it can have longer lasting benefits. And so whether helping yourself or helping the industry at large, submitting a comment, within the next 20 days can be of use for a lot longer time period than just the immediacy of today.
Right. And it certainly can be used as a basis, as you said, for substantive information. So, we just encourage people to write public comments, submit them. I mean, I do it all the time. I think the last one I did it was for the proposed rule on manufacturing standards or whatever it was, right?
The TPMPs,
yes,
right? The tobacco product, the manufacturing standards.
Right.
Yep.
Yeah, which we still haven't seen that final rule.
Correct. So, it can take a while before they come out with it. On the other hand, some can happen very quickly. Not that a notice of proposed rulemaking was put out, but I remember when the PACT Act had come into effect, it was, hey, we don't need to do a notice of proposed rulemaking. This is in effect in 60 days. Right. And meanwhile, the post office can't keep up with the change. And they said, forget it, but the agencies aren't always talking with one another.
No, and ATF certainly had a lot of education to go through.
Indeed. So, recognizing the complexity to preparing this, everybody who's attended this today live, we have a bonus for you, which is related to the right way to prepare and submit a comment. And this will be coming to you probably later today, and if not tomorrow. But we wanted to help you understand what's the right way. We give you a template on what should go where. We provide you with things to include, things not to include. And then at the very end are step-by-step instructions on how to actually file this, okay? This will be coming to all of you, of course. If anybody thinks, it'd be better to have some eyes look over it, our firm is here to help. You can reach out to us at any time. Okay, and our information is at the bottom of this handout, which we'll be sending to all of you. Mark, I think it'd be a good time to see if you had any final remarks, and once we do those, we could open it up to Q&A.
Sure. Well, first of all, thank you, Deanna, for having me today to discuss this important proposed rule by the FDA. It's been a pleasure to be here. I would just say in my final comments is that everyone that's in the vape industry really, I've said this from the very beginning, and I still believe it today, needs to take active positions to defend their businesses and their customers, right? We are at the forefront at providing alternatives. And if it wasn't for the vape industry, Granted, we wouldn't have these rules right now, but I encourage all of you to write public comments and submit them before October 15th, because it does have an effect. It does make a difference.
It does. And I know certainly many of our clients had come into the vape business because they themselves had used vaping to come off of cigarettes and some off of nicotine altogether.
Mhm.
And as you and I remember from when we met at NYU, we were at a joint conference between their dental school and the Department of Public Health. And the then director of Center for Tobacco Products, Mitch Zeller, he came and spoke, and he described how vaping falls somewhere in the middle of what FDA calls this continuum of risk, is how they
Right.
look at nicotine addiction.
Sure.
With traditional combustible products being the worst at one extreme, and then products like the patch at the other, and vaping falling somewhere between those two extremes. And Mark mentioned, hey, without vape, where would smokers / vapors, where will they be? And we know where they'll be. They'll be back to the worst kind, to the combustible tobacco products. So, all right. So with that, I want to open it up to Q&A. And I think we're just going to ask if you want to unmute yourself and ask your question. And I'll just give a moment for any questions to come in. Well, so I just want to go ahead and thank everybody then for joining us today. And again, Mark, thank you so much for participating in this important town hall with us today.
Thank you for having me.
We'll share this on our YouTube channel. Again, we invite you to subscribe to it, sign up for our newsletter. And if you would like to run questions by us or get further information related to how to submit a comment, feel free to contact our office. All right. At this time, I think we'll go ahead and close out the program. So thank you, Mark.
Thank you, Deanna. It was a pleasure.
Take care, everybody. Bye-bye.
Bye.
Subscribe and click the bell icon so you'll be the first to know when we upload a new video. Check out our playlist if you want to see more of our videos, and comment below and introduce yourself. We'll see you soon.